Welcome to Seminole Sidelines. Today, Jerry Cutts, Osceola publisher. I'm Bob Ferranti, Osceola editor. We are joined by a special guest, an Osceola friend, and Will Fixel. His first job was at the Osceola many years ago, so we appreciate him joining us. Will is a longtime real estate attorney specializing in private property owners and business subject to eminent domain. A longtime Tallahassean. Florida State fan. I think we're all Florida State guys here. Let's readily admit that. But he went to Duke as part of his undergrad and then Virginia for law school. So we appreciate Will jumping in here and talking with us a little bit about, look, we know we can easily get into the legal weeds. Let's try and bring it up to something that we can simplify it as best we can and answer a lot of your questions as you have about this Florida State ACC court case that's, of course, going on now in two states, in North Carolina, in Tallahassee, and yes, there is a Clemson case too. So let's start there. And Jerry, let's start with you with your first couple questions.
Well, Bob, before we get too far into this podcast, I'm going to alert our listeners that I got some very sage journalistic advice from a retired federal judge. And that was, don't try to lasso a tornado. This is a complicated lawsuit, which will get into a little bit here, and it can go in any direction at any time. And so we don't want to get ahead of our skis and try to predict. What we're trying to do here is just build an explainer. And as laymen, Bob and I probably have the same questions a lot of you all do. And so we're asking Will to go back to his first year of law school on some terminology. Will, is that a reasonable goal, do you think, for these podcasts?
Yeah, absolutely. First, let me just say thank you all for having me. As Bob said, my first job I ever had was back in the mid-'90s when I was in high school, before I could even drive, working for Jerry in the Osceola. It's an important institution to me. Jerry's an important mentor to me, and anything I can do to help your readership understand what's going on, I'll be happy to provide. And thank you for having me today.
All right. Do we want to start at the beginning, Jerry, or?
Yeah, you go ahead. I'll let you ask the first one.
Okay. So, Will, at heart, what's the foundation of this case? What is the case about, and why are we in court, Florida State versus ACC?
Yeah, I think when you look at a case like this, you got to say that the business interests of the entities have diverged. At one time, Florida State University was a happy member of the ACC, doing well back when I was working for Jerry in the 90s and for a decade or so after that, 2 decades after that. At some point, the interests diverged. And those interests are tied together via contractual agreements between the ACC and FSU. So when you have that situation and when you have business interests that have diverged that were previously aligned, then you look at the documents themselves that bind those two entities together and you say, well, what happens if they break apart? What happens if there's a breach of that contract? What happens if the parties need to go their separate ways? And in this situation, for a variety of reasons, I think it's clear to all FSU fans at least, and likely fans of other ACC institutions as well, that it's time for certain institutions to potentially to leave the ACC, and that's what FSU publicly has stated that they're interested in doing. So the question becomes, what are the ramifications of that? What happens if that occurs? And given the contractual arrangements that exist between the FSU and ACC, and this is well publicized and it's been discussed at length on the Osceola, with the Osceola, there would be potentially very significant implications. There's major 9-figure exit fees that FSU would potentially have to pay, and then also there's this question of the grant of rights, whether FSU would be able to obtain media money for its media rights for something like 10 to 15 years after they left the conference. And so what FSU expressed an interest in doing was going to court to figure out, well, is that really enforceable? Is that really what would happen if we left the ACC. And so FSU expressed an interest in filing a complaint. They had certain obligations as a public institution in Florida to have certain trustee meetings, and they had certain obligations to have those trustee meetings be open to the public. And so they did that. And the ACC, when they got wind of what was going on, because it all had to be public, went forward and filed a lawsuit the day before Florida State was about to file its lawsuit. So the ACC filed a lawsuit in North Carolina, telling the North Carolina courts that, or asking the North Carolina courts to find that the contracts that FSU and the ACC have are binding, and if they're broken, that the implications would be severe. And then a day later, Florida State filed lawsuits in Florida saying, we don't think that these agreements necessarily are binding. We think they aren't binding, and we don't think that they are enforceable, that we would have to pay this 9-figure exit fee and lose our media rights for over a decade, for about 15 years. And so for that reason, we have 2 cases moving forward in 2 jurisdictions, one in Florida, one in North Carolina. North Carolina was filed first by a day.
So, Will, a couple of points of clarity here. Florida State's Board of Trustees voted to file what is called a declaratory judgment, asked for a declaratory judgment. Can you explain what is that? What is a declaratory? What are they looking for from the judge?
So most lawsuits, one party is complaining, you file a complaint, right? One party is complaining of the behavior of a counterparty, and they're seeking money. They'd like to be paid damages for whatever has happened to them, whether it's a breach of contract or a slip and fall, or in my cases that the government has taken property from you and you have damages and taking value that results from it. This is an exception to that. Declaratory judgment action is when parties are filing a lawsuit saying, we're not seeking money at this point. We're really seeking clarity. We want to know from the court what our legal rights are so that we can move forward without having to first, for instance, breach a contract and then figure out later what the damages are. So what a declaratory judgment action is seeking clarity from the court that identifies and provides what the legal rights are of the parties to that, for instance, in this case, to that contract. So Florida State is asking for the court to agree with Florida State that the exit fee, 9-figure exit fee, plus the grant of rights are invalid under Florida law, that FSU, if they left the ACC, would not have to abide by those terms of their arrangements with the ACC. And the ACC is asking the North Carolina courts to find that those are valid terms and enforceable terms, so that if FSU loses, they would have to pay the 9-figure exit fee, and the ACC would retain FSU's media rights until I think it's 2036. So FSU would in effect not be paid for if the ACC is right and FSU left the ACC. The ACC is looking for a declaration that FSU would not get any media monies or monies from its media rights until the conclusion of the current deal with the ACC and ESPN.
We're going to come back to that in a minute under Alan Lawson's arguments as to why that a declaratory judgment is inappropriate. But I wanted to ask you, we're in this phase of the lawsuits in which each side is arguing for venue and in their respective states. And both judges have basically ruled that they have, in Florida, Cooper ruled that it would proceed in Florida, and North Carolina ruled it would proceed in North Carolina. Let me just ask you this. We're 3 months in already, 3 or 4 months in. I've been told this battle for venue can last months, if not a year or more. Can you talk to us a little bit about what is the battle for venue? Why is it important? How is it decided? Can it be appealed? And in your experience, how long can an issue like this drag on?
Yeah, so venue, just very basically speaking, is where's the case to be held. That's what we're talking about. In a sports analogy, it's, are we playing at Doak Campbell Stadium or are we playing at Hard Rock down in Miami? Where's this case going to be held? It is highly unusual, but it is the circumstances in FSU versus ACC case for two courts to rule that venue is proper in two different locations, particularly two different states. That's highly unusual. For instance, I have been practicing now for almost 20 years. I first became a lawyer in 2005, so I guess it's 19 years. I've never had that scenario play out, and I think most lawyers would say that they haven't. It's very unusual for two locations, much less two states, to move forward with complaints that are virtually identical, right? So how long can it drag out? First of all, I think the Osceola's readers and viewers should know that both courts at this point have ruled that venue is proper in their states, in their locations. So the North Carolina Business Court has ruled that the parties can move forward in North Carolina, and in Leon County just this week, the sitting judge John Cooper ruled that it's proper in Florida too. The reason that can happen is because courts can see the same issue differently, right? So in North Carolina, the courts said, well, North Carolina was the first to file. There are North Carolina interests in the case. The ACC is a North Carolina institution, and therefore it's proper to go forward in North Carolina. The ACC's attorneys in Florida argued, well, since we're going forward in North Carolina, this case needs to be either dismissed for improper venue or stayed because we need to go forward in North Carolina first. And the Leon County Judge Cooper said, well, not necessarily, because there is an exception to that first filed rule, which is that wherever the case is filed first is where it should move forward for what's called an anticipatory filing. So Judge Cooper found that since FSU had to, in order to file suit, had to do so, the open sunshine, had to have the Board of Trustees meeting. It effectively tipped off the ACC that it was about to sue, and that I think he very understandably ruled. Then the ACC rushed to the courthouse in North Carolina to file a lawsuit. That's called an anticipatory filing, which involves what's called forum shopping. So it's a party that's trying to pick the location of the lawsuit via means that or what I just described, that they know that another party is about to sue them. They want the case to go forward, for instance, in North Carolina. So we're going to rush to the courthouse to file that. So what Judge Cooper said is, in that scenario, I don't necessarily have to follow the first filed rule. Just because it was filed first in North Carolina doesn't really matter. What matters is that it was an anticipatory filing, and that because it was, venue is proper in Florida, because this is really where the action should be held. This is where it would be held if Florida State didn't have to have that Board of Trustees meeting alerting the world that they were about to file suit. So forum shopping is something that's discussed in the law. Sometimes defendants usually like to be in federal court, for instance, or in this state or that state, and that's what Judge Cooper was worried about in the hearing that occurred earlier this week, and that's why, in part, he ruled that it can go forward in Florida. So you've got two courts that both believe and have ruled that it is proper for these cases to go forward, and they're in two different states. So again, that's unusual. That's an unusual procedural posture for litigation. And then, as Bob said, you have Clemson in its filed suit on very similar claims as well in South Carolina. So it's definitely complex litigation.
Yeah, it's interesting. We're going to get back to that point too, which I think is really significant. In North Carolina, Will, that judge, he didn't offer a bench ruling. He waited to respond to what he had heard. Is that uncommon for a judge to do that, to take some time before issuing a ruling?
No, both. You see both. Sometimes judges take it under advisement, so they've heard all the arguments of the parties. If there's an evidentiary proceeding, they've reviewed the evidence, they've heard the evidence, and they want to think about it. They want to take their time to write a decision, and they want to do it themselves. That's that happens. And then also sometimes judges will just have an idea and an understanding of where they're going to go right away, and they'll just rule from the bench and say, I'm going to deny the motion for improper venue of the ACC, like Judge Cooper did. And I believe it can go forward in Florida, and then judges will ask the attorneys for the parties, usually the winning party, to draft a proposed order that they pass by the opposing party, to make sure that it's consistent with the court's ruling, and then present it to the judge for signing. Even then, the judge can still edit the order. I mean, it's the judge's order. But if you're doing your job as a lawyer and you follow what the judge has ruled, which you should do, typically they'll sign something very similar to what's been presented.
Okay, well, on Tuesday, we were in the Leon County Circuit Court for Judge Cooper to hear this case from both sides. Will, you've been in the courtroom in front of Judge Cooper before. Tell us a little bit about him. Who is he? He's
a very experienced judge. I think he's been on the bench for over 20 years. I don't think you'll find a lawyer in Leon County who doesn't respect Judge Cooper, but respect his intellect. He's very bright. He's very well seasoned. And he is a judge that I certainly have a lot of respect for. And I think in the legal community, the lawyers here have a tremendous respect for. I think he's probably been the longest tenured judge on the Leon County Circuit right now. And he, in private practice, had a successful practice, had his own firm at one time. And I believe he worked for a very renowned lawyer in town named Dexter Douglas, who was as prominent a lawyer in Tallahassee as there's ever been. So Judge Cooper is very, very highly respected, very intelligent. He calls balls and strikes very fairly and equitably for the parties. He's going to rule the way he thinks is appropriate. And that whenever I've been in front of him, that's what I've always found.
As long as we're talking about the players on this ball field, what can you tell us about the ACC's Florida-based lawyer, Alan Lawson, who is arguing the complaint for the ACC in front of Cooper? Tell me about Lawson.
I don't know him personally. I've never met him, but I am aware that he was a former Florida Supreme Court justice. So, because of that and because of his general reputation in town, he's a very respected attorney. You don't get to be a Florida Supreme Court justice unless you're an excellent attorney and one that has the highest ethics and that people respect in our community, in the legal community. And so he's very well respected. I don't know him personally, but I think both parties, frankly, have excellent legal teams, and Alan Lawson is certainly part of that. He was a former Supreme Court justice, and that shows.
Speaks for itself, doesn't it? Yeah. So FSU's team of lawyers here in Florida include David Ashburn and Peter Rush. Just to give our listeners some idea of the quality of those people, what can you tell us about them?
They practice at a law firm called Greenberg Traurig. That is a national, not international law firm that's a powerhouse. It's a firm that, as I understand it, was founded in Florida, I believe down in South Florida in Miami. I've worked with their firm before in a couple matters years and years ago. I don't know those two lawyers personally, but if they're top-level partners at that firm, which they are, you can assume they're legal powerhouses as well. And from what I've heard in the legal community in Tallahassee, they're both very, very respected. David Ashburn is local here in Tallahassee and is very highly respected. Peter Rush is, I believe, from South Florida, West Palm Beach area, but has an expertise in sports law, so it makes a lot of sense why those two would be the top dogs on FSU's legal team. And I think, unsurprisingly, both parties here, the ACC and FSU, have come out and hired legal powerhouses.
Will, Lawson's motion to dismiss was pretty detailed, lengthy. I don't think Judge Cooper appreciated the length of some of these motions, right?
He did not. He likes them to be more succinct. He even commented on font size usage and page numbering just to help things speed along.
I'll just say I've been there. I understand.
So, judges, they got a full docket, and I guess they want you to get to the cut to the chase, which is probably true for most of the people who read my stories. But at any rate, Will, can you summarize Lawson's motion to dismiss in a way that we can understand it and what it was? Bob's going to ask this in more detail, but his denial of that motion for improper venue in a minute. If you could just summarize what Lawson's argument was.
Yeah. So just broadly speaking, I think what would be most helpful is just to discuss where we are. So the ACC filed a complaint against FSU in North Carolina. FSU filed a complaint against the ACC in Florida. The first steps in that proceeding are, first, are we in the right location? Like, did the game get scheduled at Doe Campbell Stadium and we're at Doe Campbell Stadium, right? That's the venue argument, okay? Are we here at the right place? So as I said earlier, the North Carolina courts have said we're in the right place in North Carolina, and the Florida court has now said we're in the right place in Florida. That's unusual. Jerry, you asked me earlier, well, how long could that just issue linger? And you asked about appeal, and I didn't address that. So in Florida, and I don't know about North Carolina, but in Florida, most appeals happen at the end of a case, right? When there's a final judgment in it. That makes sense. You want the whole case over before you go see whether there's been an error made in that case. One of the exceptions to that rule in Florida, as I understand it, is for an interlocutory appeal for decisions on venue. So, that's not something I have an area of expertise in, other than to generally know that is a, generally speaking, an area of law where you can have an exception. You can have an interlocutory appeal. So I think there's this first question on Judge Cooper's ruling, at least on venue, whether that gets to be immediately appealed or not. I have a general understanding that venue decisions can be appealed immediately, but that's not an area of expertise. So that's going to have to be studied by those lawyers, and we could have potentially a pause in the case at some point to deal with that interlocutory appeal. Okay, so that's kind of lingering out there. That's got to be studied and researched by the lawyers for the ACC and FSU to see, well, we don't agree with this venue ruling, and we're going to the First District Court of Appeal in Florida to see if we can get that remedied immediately. There may be a similar procedure in North Carolina for FSU to appeal that ruling. I'm not sure because I don't practice in North Carolina. But in Florida, at least that has to be researched and understood by the lawyers, because there's a general understanding there can be what are called interlocutory appeals for venue decisions. Let's just get past that issue of where should this happen. Is this at Doe Campbell Stadium or is this at Ben Hill Griffin Stadium, right? Then we talk about what's the next step. And that next step is, and this has already been decided in North Carolina, not in Florida, is, okay, a complaint has been filed. I'm going to take everything in that complaint is true. Even if it's not, I'm just going to, as a judge, I'm going to assume everything in here is 100% accurate. Has a complaint been properly alleged? Are these proper allegations, right? And that's what has already been determined in North Carolina, and what the North Carolina judge said was almost all of the ACC's allegations are proper and can move forward, with one exception related to a breach of fiduciary duty, that apparently FSU did not have that type of fiduciary duty to the ACC. But for all intents and purposes, the vast majority of the claims that the ACC has made against FSU can move forward in North Carolina, according to the North Carolina judge. Judge Cooper has ruled in Florida that, yes, we're in the right place. We're in Florida, in Leon County, this is a proper place. He has not yet ruled that these claims can move forward as alleged in the complaint. And so, Jerry, we've talked about this in the past, but this next part of this in Florida, this motion to dismiss, is like, did you show up with the right team, right? Are we playing the right game, right? and so it's a very low standard to beat. But, Florida State and Miami play baseball tonight out at Dick Howser Stadium. Did you show up with 9 players, right? And we're in baseball bats and gloves, right? Or can we move forward just because what you've alleged are proper causes of action in the state of Florida? And it's a very low standard, and so to meet, and it does not mean you're going to win the case eventually. It just means you can move forward to what then is called discovery, which would be where you take depositions and produce documents and all that sort of stuff to develop a factual evidence and record in a case. But first, you have to say this complaint, as alleged, that this is these are proper allegations and claims that can be made and can move forward. And so, Judge, the ACC is saying that hasn't been done by FSU for a variety of reasons, and therefore, Judge Cooper, you may have ruled that we're in Florida, but and this is proper to go forward in Leon County. But now that we're here, it still needs to be kicked out because the allegations aren't proper. Don't rise to the level of a proper action.
And that's what he'll hear on the 22nd?
That's my understanding. And he'll also hear whether there could be a stay in discovery. In other words, if FSU gets over the motion to dismiss, then that these are proper allegations. Well, still, for some reason, we don't need to move forward with discovery, and that probably ties back to the North Carolina case. Let us move forward with discovery in North Carolina and not have a duplicative effort, would be my guess as to what that is about.
So, Will, what happens if we have these two cases going on in two different states? What happens if one of the two cases gets to judgment first?
Yeah, I mean that this is unusual. I mean, I'll probably practice for 40 to 50 years and will likely never have this happen. It's just an unusual procedural posture. But there are general rules of what's called comity and full faith and credit that, and I'm not an expert in this, but just as a general principle in the law, one state, say Florida, must respect the laws and judgments of another state, North Carolina, or vice versa, and vice versa. So the concern and the reason why this is disfavored for two similar cases to be moving forward in two separate courts, and really Clemson's allegations are very similar to Florida State's as well. So you really kind of have it in three different locations. It's hard to see how Clemson could win or lose and that not be the result in Florida State's cases too. The principle of comity, it's called COMITY, and the full faith and credit clause of the United States Constitution, just generally speaking, say that if you have a judgment in one state, that must be respected by another state. So if you've got a judgment in North Carolina, there will be a legal argument that must be respected in Florida and vice versa. So what that creates is what's called a race to judgment, right? Both parties are trying to get their cases moving forward as fast as possible in whatever jurisdiction they think is best. And I'm not 100% convinced that that's even the case, that there are jurisdictions that are more favorable than others. But the idea is we're going to race to get to judgment in one of those cases so that it has to be respected by the other. And then that can be litigated as to whether that's true under these particular facts and circumstances.
And of course, whatever happens there, that can also be appealed, can it?
Absolutely. And probably would be if it got to that point, as would the judgment decisions. And so you're looking at, in complex litigation like this, you're looking at multiple potential appeals, multiple potential avenues for this dragging out for a long time. Or it may not drag out for a long time. I mean, that's the tornado you were talking about at the beginning, Jerry. I mean, for all we know, they're all discussing settlement right in the room, and right when we end this podcast, they'll say it's over.
I don't
know. I mean, we just don't know, but we know it's complex. We know there's a lot to this.
So as we were preparing for this, I got a text from one of our writers with another one of these, where's the tornado going to go moments that settlement is being worked out, by the ACC and ESPN. And so who knows, right?
That could be true, or it could be not true.
I think we spend more time, Bob and I do, trying to chase down bad information than we do, good information. So there's so many things out there. Bob, you've got a question about trying to lasso that proverbial tornado.
Yeah, I mean, we've kind of discussed this as hey, could it be appealed? I mean, all these decisions, I guess, in theory, could be appealed. What are your thoughts on that?
Yeah, I think at the end of the day, it's absolutely when this case is over, there could be an appeal. I think there is a question, um, and like I said, my understanding of the general rule on interlocutory appeals during the middle of a case, um, uh, is that venue decisions can be appealed in an interlocutory manner. So meaning that they can that potentially, and again, there could be an exception to that general rule because I don't I don't litigate venue very often. I have, but I don't do it very often. But the general rule is that venue decisions can be appealed in an interlocutory manner. So that's something I can promise you that the FSU's and the ACC's attorneys are researching, and whenever that order is entered on venue, it could be. There could be the first appeal, within 30 days. And then the question is, do we have to pause discovery, just like the motion to stay discovery, while that is on appeal? Then you have in the background this idea of a race to judgment. Can we get to North Carolina first, or can we get to a Florida judgment first because the other may have to respect it? So there's a lot of moving parts to this. That's the tornado Jerry was talking about. And then also, kind of to that settlement question we were talking about. And one thing that concerns me about settlement is just how many parties have interests in this lawsuit. I mean, you've got 17 member institutions to the ACC. You've got media partners. You've got the ACC itself. You've got the other conferences, the Big Ten and the SEC, that have an interest in this. And
The
so
networks.
the networks, exactly. And so I wouldn't want to be Jim Phillips, the commissioner of the ACC. I'll put it that way. He's got a remarkably difficult job because how do you settle the case and do so in a manner that has an ACC that's still standing? Because you can't settle the case if the ACC is going to go away. At that point, you just have to litigate it and hope you win. So for the ACC to settle, there must be some scenario where the ACC continues to exist after your Clemson's, your Florida State's, potential, maybe North Carolina, maybe Miami leave. And what does that look like? And that's really hard. So I'm sure there are settlement discussions going on. It's just really, from particularly the ACC's perspective, with so many different interested parties, it's going to be very, and the gravity of the litigation, the importance of this litigation to the ACC, it's going to be difficult for the ACC. So not impossible. Like I said, it may come out tomorrow that the case is over, but it's just going to be a challenge. But that's what you have good lawyers for.
Couple questions, Will, and then we'll wrap this up. I know you've got a busy docket today. One question is, on this issue of venue, I've heard from a number of lawyers that, you want to, if you're going to host a softball game, you want it in your backyard, you want the umpires. Some people believe that, and I think most of our fans worry that if North Carolina were to win the battle of venue, that, it's a really bad thing. What's your opinion about the court system and the importance of venue?
It matters, but it's not determinative. We live in a great country with a great legal system. It's not perfect. No system is perfect, but what we do is we have laws and we have records, facts, right? Where do those facts that can be developed in a case fit within the laws that exist? And there's no perfect answer for any case. Most cases have to get litigated because it's not completely clear. If it was completely clear, parties wouldn't be in court, right? But most of the time, the overwhelming majority of the time, because of the different levels that you have, you've got the trial court, you've got appellate courts, you've got multiple layers of appellate courts, correct decisions are made in our legal system, and they're based on the law and the facts. And what lawyers do is they're nonfiction storytellers, right? They tell stories based on those facts that exist, that you can develop in evidence in a record, and within the constraints of the law. And most times, and I can say this, having practiced in front of Judge Cooper a number of times, he definitely adheres to this, that the cases are going to be decided on those facts and laws. And personal feelings I don't know that I've ever been in a case where I really thought that a judge's prejudices towards one of the parties made a difference, and that certainly isn't going to happen with Judge Cooper. So it matters because you want to be in your venue because it's closer to home, but in my mind, it's not going to be determinative.
You talk about that generally in a lawsuit, there's case themes. And you talk about nonfiction storytelling, and I think you mentioned that the FSU and the ACC's case theme is kind of the same.
Well, I think they touch on the same issues. I think to your readers and the watchers of this and listeners of this podcast, this is to me the most important as an attorney looking at this. There's a whole lot of pre-merits things that are going on. Where are we going to have this case? Is the complaint right? But at the end of the day, to win a case, as I said, you've got to have a compelling nonfiction, meaning based in reality, based on evidence, story that fits within the boundaries of the law. That's what lawyers do. So looking at this from an attorney perspective, that's what I'm looking at when I read these complaints. At the end of the day, when these judges are deciding this case, what am I going to be up there telling the court? And I think what's most important that's happened so far in all of this isn't the venue decisions. It's that those case themes are starting to shine through in the documents that the parties have filed. For the ACC, as best I can tell, the case theme, if I was representing the ACC, would be very simple. It would be buyer's remorse. That FSU signed these contracts, that they are a sophisticated party, and that now, decades into them, they're unhappy with it and are trying to get out of the contract because they're just unhappy with the contract. They just have buyer's remorse. They wish they hadn't signed it, which is I think we all have an instinct in America that that's not a reason to be able to not fulfill your contractual obligations. We just don't like this contract, right? And that's I think Alan Lawson and his team are going to be able to argue compellingly for that. And then equally as compellingly, I think FSU is going to have a case theme that is, it doesn't matter if we sign this contract. The laws of the state of Florida and of North Carolina do not allow these types of contracts that have what are called unconscionable penalty provisions to be enforced. It doesn't matter if we signed it. It's just not allowed. And the ACC should have known that when they drafted these documents. And the reason it's not allowed is because there's a general principle in American law that two parties to a contract are not bound together. They're bound together only to the extent that if one party wants to leave that contractual arrangement, that they can do so by paying the damages that they're going to actually accrue from breaching that contract. So that those damages have to be tied to the economic realities of one of those entities breaching the contract. And that's a fundamental provision in American jurisprudence. And the violation that the ACC has in this contract that there is this grant of rights contract and the exit provision contract is that those damages do not match the actual amount of money that the ACC that FSU would have to pay if it leaves the ACC. It would be greatly in excess of that, and the law provides that is not allowed. And so, where I really think FSU could really get to have a compelling case is to why that legal principle is in place, and that's what all these other allegations the ACC is making or the FSU is making that says that the ACC has misbehaved after the entry of this contract by not really fulfilling its obligations to FSU. So you have to ask yourself, why would the ACC act that way? And the answer is because the ACC was sitting comfy in their chair knowing FSU could never leave, right? That if FSU tried to leave, we'd bankrupt FSU. Not because of their having damaged the ACC, but just because of this oppressive contractual provision we have. And if FSU can make that argument that can tie the legal theory of the case to the actual improper contractual provision, to the ACC's behavior after that contract was entered, that's going to be a very compelling case thing. And to me, what's starting to take shape are those case things. And that's what good lawyers are going to do, and both sides have them. And I think that's what you're going to see if this case doesn't get settled and it actually gets litigated extensively.
I think we want to close with that because one of the themes in the courtroom on Tuesday, Judge Cooper talked about his background, his experience. He said he was a mediator for 10 years. He clearly likes the concept of mediation when two sides can agree to such. So let's wrap up there. How likely is settlement? How likely is mediation as a vehicle toward an end? What are your thoughts on either of those?
Yeah, settlement occurs in 95% of civil litigation plus, maybe even higher. And so eventual settlement is likely. When that will happen, I don't know. Mediation is a procedure with which I'm very familiar with, in which judges require parties to go sit down with a neutral third party to try to get a case settled. And you have a neutral third-party attorney there trying to facilitate that. And so almost certainly the parties will go to mediation. But how likely is settlement? Likely. When? I don't know. So,
lots of
Jerry,
questions
you'll get a
for
kick
us
out
still
of
ahead.
this real quick. I think I got my dad, your old friend for 40 years, knocking on the door telling me I got a meeting to go to.
Yeah. So listen, Will, we really appreciate the time you've taken. And I think this is really helpful for our listeners to kind of have a balanced, objective look at what a case like this really is. So I appreciate you taking the time with us.
Well, thank you for having me. And if you need me anytime in the future, let me know. Happy to help.
Your Seminoles kick off the 2024 football season in Dublin, Ireland, as they face the Georgia Tech Yellow Jackets in the Aer Lingus College Football Classic. Join fellow Florida State fans on a trip you won't soon forget. Game tickets for the August 24th matchup are now available through Florida State Athletics Ticket Office and selling fast. Visit Seminoles2Ireland.com. That's Seminoles, the number 2, Ireland.com. And go Noles!